Hello everybody, I'm Astha Rath and I'm a legal faculty at CLATapult. So today we'll be learning about a few concepts with respect to the contract law, and number one being what is a contract, number two being who can enter into such a contract, number three being what is a valid contract. So starting with what a contract actually is. A contract is a legally binding agreement. Now what is an agreement? One person has an offer, the other person accepts the offer. That is when there is an agreement. And now, if an agreement is legally binding, then it is a contract. Now, let's take an example of what an offer and an acceptance is. Number one, if a person wants to sell their bike. So, let's say they ask a person B that, hey, would you like to buy my bike for 10,000 rupees? That is an offer. Now, what are the conditions in that offer? Number one, that particular bike. And number two, the amount that has been prescribed for the bike, which is 10,000 rupees. Now, when B has to accept this offer, he has to accept two things. Number one, obviously the bike. And number two, the price of that bike. So, when B accepts the offer, then it will be an agreement. Now, we have the agreement of obviously being sold the bike to B and B accepting it. Now, what is performance of a contract? Performance is when A finally takes the bike and delivers it to B. Then performance is already also done. That way, now we had an agreement. This agreement would be legally binding to be a contract if certain things are fulfilled. Number one, the consent being free. Number two, there being capacity to enter into a contract. Number three, a legal object. Number four, a legal consideration. And number five, the agreement not being in violation of the existing laws. So let's come to free consent. What is free consent? Free consent is when the acceptance given to the offer is free and willingly given. Number one issue with free consent could be if the acceptance has been given because of coercion. What is coercion? Coercion is when one person has been forced to give their consent. An example of coercion could be if a person is placed at gunpoint and asked to accept. Example, in a more elaborate way, could be, let's say, a person who has entered into somebody's house without their permission, and while the owner was sleeping, has gone up to the bedroom, asked the owner to get up, kept a gun at their head, pointing at their head, and asked them to sign a contract or an agreement, which if the person signs on, would be essentially selling their own house to the person that has illegally entered their house for a consideration or an amount of rupees 1,000. Now, the value of the house could be in crores, but if they obviously sign that contract and if it is considered to be legal, then they would be selling off their big house for a mere value of 1,000 rupees. It is very essential to remember that consideration does not have to be the market value of things. Consideration needs to have value in the eyes of law. So even if a contract has been entered into between two parties where the value of something in market value could be in the thousands, but the contract is for 10 rupees, that also consists of a valid contract. However, here the situation is different. Why? Because there was a gun pointed at that person's head. Therefore, it was coercion. When it's coercion, it is a forcefully brought out acceptance which will not be considered. So this is not free consent. Now that we've done coercion, so now moving to number two. Number two is undue influence. In undue influence, we look at few relationships between parties. One being at a greater level of influence to the other. Examples of these kind of relationships could be a doctor and a patient, a guru and their disciple, a teacher and a student, etc., etc. Even for that matter, within families, if your father is at a more influential level than you and you get influenced by them, then even a father, a son, father, daughter, mother, son, all the family members can also fall under undue influence. Now, in terms of undue influence also, why is it important to understand whether or not it is free consent is because when somebody has that sort of an influence on you, whether or not what they have made you do if their advice was for you to sign an agreement, whether or not that was pre-consent will then be evaluated by the court. Therefore, even if there is undue influence, that amounts to not free consent. Now, moving on to number 3. Number 3 is misrepresentation. Now, misrepresentation is when one party has, without any malice on their end of course, misrepresented the object or consideration in a contract, the object that has to be sold, something that is important for that object was not mentioned to the other party. An example could be if one party wants to take a house on rent, the other party is of course the landlord, and they are signing an agreement. However, the landlord is themselves not aware of the fact that electricity in the household has been shut for the last month or so. So while they state that this house is in a complete condition to be resided in. However, once the tenant resides in that house, they realize that there is no electricity. So here there was no malice on the landlord's end because they were of course unaware of the situation. Still, it was misrepresentation because they represented the house to be completely habitable and it wasn't. Now, number 4 is fraud. Fraud is misrepresentation but with an element of malice involved. So in fraud, they do something or they represent something that induces the other party to enter into the agreement. However, whatever they have represented is false and they are also aware of the same. So take the last example that we discussed. In that, just add the fact that the landlord was actually aware that there was no electricity in the household, and then that becomes fraud. So now that we've discussed these, final one, which is the 5th element, is mistake. Mistake is when an essential element crucial for the contract is something that both parties are at a mistake on. So one party could be expecting something and the other party could be accepting something else. So if one party is expecting that the contract is about buying a certain property, the other party actually is accepting the contract with respect to some property somewhere else in some other land. So here clearly the very crucial element that is present in the agreement is that property, and both parties are not aware about what the actual property is all about. This is why it is very important that in terms of mistake with respect to an essential element to a contract, that is again void. With respect to coercion, undue influence and misrepresentation, they are voidable contracts. Now, what is a void contract and a voidable contract? A void contract does not exist, does not have any legally binding effect. However, a voidable contract is always void if the aggrieved party wants it to be void. But if the aggrieved party wants to go ahead with performance of the contract, then it remains active. So that is the difference between voidable and void. So the next thing we talk about is legal capacity. With respect to legal capacity, 1, that is a minor, 2, that is somebody with of unsound mind, and 3rd, if somebody as per the laws of the country is not capable of entering into a contract. These are the 3 kinds of people that do not have legal capacity. With respect to minority, of course, in India, as long as you're not 18 years of age, you cannot enter into a legally binding contract. But there is an exception to this, which is if there is a contract for necessities. So only with respect to contracts for necessities can minors enter into it. Other than that, minors do not have the capacity to enter into contracts. Number 2 is people with unsound mind. So there's an exception to that as well. Because in certain situations, a person can be of unsound mind at some points of time and be completely capable of making rational decisions at other times. So when that person is capable of making rational decisions, then that person can enter into contract, and then when they are of unsound mind, they cannot. 3rd could be an example of, let's say, an insolvent person. An insolvent person, as per the laws in India, do not have the right to enter into legally binding contract, and therefore even they are incapable of the same. Then final elements would be legal object and legal consideration. Now it's a given, as long as an object or consideration in a contract is not illegal as per the current laws, there will be legal object and legal consideration. Final thing is if a contract is expressly void as per the laws in the country. An example of that could be commercial surrogacy contracts, because in India currently commercial surrogacy is illegal. Therefore, if there is a contract for that, that would also be patently illegal. Now with that, we come to an understanding of who can enter into a contract. and what is the capacity necessary for the same. Thank you.